just before resuming the second topic under consultation,
Yes.
I said I would go back on two things, or think some more about two things. The first was Lord Justice Dingemans' question about the Public Order Act 2023. I haven't yet got final instructions on this, but having thought about it again over the short adjournment, it's page 63, tab 5 of Authorities Bundle 1. And the question was about the structure and the way in which 34.1a worked. My inclination, if I'm allowed to put a submission in that form, is that it works in this way. You've got the concept of a physical obstruction preventing as one thing, and then a separate concept encompassed by the two commas, hindered to a more than minor degree. And I say that's the more natural way of looking at it, at least for the moment. That's the more natural, appears to me to be the more natural way of looking at it, because prevention is itself an absolute concept, one. Two, the commas appear to be used pretty deliberately. And three, if you read A with B, that rather tends to support that approach, because you've got the same basic idea but used in a slightly different way, and structure used in a slightly different way in B. You see again, are prevented, in this case, from making or receiving. Or, and then brackets, the commas are all in the same place, or suffer a delay that is more than minor to the making of the delivery. My Lord the Vice President asked about the position we took in relation to the community point.
Yeah.
And my Lord, so far as that is concerned, I really haven't got anything further at this stage to say orally. We rely on paragraphs 38 to 42 of our skeleton argument, which seek directly to address that point. But if there are further particular points, I'll pick them up and reply very briefly. But for the moment, I'm content to take my stand on that. Yeah, I'm great. So I was going to go back to the second of the topics under consultation, and this assumes that there is a voluntary consultation in a formal sense. And the question this second topic addresses is who has to be consulted, assuming that there's been a formal consultation of a voluntary kind with someone, here the police. Who has to be consulted? And in particular, what is the standard of review? What is the correct approach in principle for a court in answering that question? You'll recall that the Divisional Court applied what it described as a broad standard of fairness, and rejected the idea that that was a rational judgment or decision for the Secretary of State about who to consult. And our position is that rationality is the standard. Alternatively, even if some fairness standard applies, it isn't a broad standard of fairness, but a test of whether it was so unfair not to consult the other group as to amount to an abuse of power. In other words, a heightened standard of fairness. The Divisional Court's conclusions on the legal standard to apply, we submit, started from an assumption, in effect, in paragraph 170, that a test of fairness applies. And it might be thought the assumption is rather borne out by the title above that paragraph, which is Fairness, Can a Selective Consultation Be Fair? Anyway, they then concluded at 178 on the standard that they didn't regard Article 39 or the various other decisions that they referred to. I think Article 39 was the one my Lord might recall, about consulting the child commissioner. You didn't. Lord Justice Baker gave the judgment with which you and the other member of the court agreed, but they cited that as, they didn't regard that as clear authority supporting a general principle that a decision maker can always, subject only to rationality, choose whom to consult in a voluntary consultation case. And then more positively, in 181 of the judgment, they concluded by saying that they take the law to be as stated by Lord Justice Elias in the Milton Keynes case. There may be circumstances where a voluntary but selective consultation exercise will render a decision taken pursuant to it unlawful. Such cases might be relatively rare. And we just invite you to note at this point in relation to 181 that the judgment of Lord Justice Elias was not, apologies to the court below for this as well, we should have picked it up, was not in fact the Milton Keynes case, but was the Appellant case we looked at earlier. I'll take you back to that paragraph in due course. I think Liberties skeleton at 53 in fairness repeats the error, but we also invite you to note that Lord Justice Elias was come to us in due course, but didn't say voluntary but selective, only selective. So it's not authority we submit supporting a fairness test at all. So there isn't any other explanation in the judgment from a point of view of principle as to why a fairness standard applies in the present case. I want to touch on some of the cases on which the Divisional Court did appear to rely, and bear in mind this is relying for the purpose of establishing a proposition of principle that it isn't rationally for the Secretary of State to judge who to consult with in a voluntary consultation situation. It's for the court to decide as a matter of fairness where it says that consultation should have gone. They relied on the Mosley case, which is the well-known Supreme Court case on consultation, and they did that in particular by referring to it at 159, 170 and 180 in the judgment. Mosley is in Authorities at tab 26. And you'll see, it'll probably be very familiar to my laws, you'll see that it was from the head note at 544 that it concerned the statutory duty to consult in the context of setting council tax reduction schemes. And you'll see at the letter G of the head note, the complaint in that case was not, I emphasise, was not about who was consulted. It was instead about the content of the consultation documents, and in particular an alternative proposal based on a transitional grant scheme. Details don't matter. That's important because there may well be an obvious distinction between the question who is to be consulted and the basic manner as to the consultation documents, whether they set out sufficient information and so on, so as to enable a proper and fair and intelligible response. In the judgment of Lord Wilson, there's a bit of a disagreement between their lordships, some of their lordships on this, but Lord Wilson at paragraph 23 he says in the final sentence of paragraph 23 what you see. And then enlarges on fairness being a Protean concept by reference to that parole board case of Osborne in 24. At 25, the gunning principles are discussed. And 26 makes the point that the degree of specificity with which they should conduct, in fairness to consultation, depends on the identity of those who are in fact being consulted. So if you're consulting a specialist audience, you might need one thing. If you're consulting the general public or section of them, you might need another thing. So that was essentially his reasoning. And then Lord Reed at 34 and he prefers to move away from the idea of fairness and more concentration on the statutory context and purpose of the particular duty with which they were concerned in that case. At 35, he makes a reference to Bapio. you'll see the essence of his reasoning really at 37 and 38. But the core point perhaps about Moseley is that Moseley was not really considering at all the question of who you should consult. It was concerned with the nature and content of the documentation and information you had to provide in order to enable the consultation to satisfy the gunning criteria, and represented a Supreme Court level endorsement of those gunning criteria effectively. I said I'd go back to Association of Personal Injury Lawyers, and I will. That's in tab 24, so a couple back. And this was the one on which the Divisional Court appeared to place particular reliance.
Excellent bundles, but it would be even better on the back, the thing saying which was which, what tab for each.
Yes, I'm sorry. Can we note it for
Blackstone classroom or library?
very well?
Every other respect are very good. So.
Thank you. Well, we'll make sure that gets fed back from everyone who's in court. So Appellant is at 24, and the relevant paragraph for this purpose, I think a single sentence or two, but it's in 36, which we didn't go through and we didn't go to before.
Sorry, which paragraph?
It's paragraph 36, my lord.
Thank you.
What's the general proposition which Mr. Nichols was putting forward? So we've got it.
Did Mr. Nichols refer to in paragraph 36? Oh, that might explain it. Not sure I'd be able to help you on 35 either, but 36 may at least target it.
Yes, thank you. So he wants to read the whole text. Yeah.
If you would, it's particularly the bit they particularly picked up on is the bit after the quotation from Milton Keynes.
Yeah.
And we submit that Lord Justice Elias there is not expressly endorsing a fairness or a rationality test. He's simply noting, and indeed that's really the thrust of Milton Keynes, despite the language used, noting that there will be circumstances in which there will be grounds for the court to intervene, but the precise basis on which that occurs is not endorsed or picked up or accepted by Lord Justice Elias there. It simply supports the proposition, as he put it, that there may be circumstances where a selective consultation exercise.
Can I just in relation to that, I mean, regardless of what Lord Justice Elias said, I mean, assuming the extract from Lord Justice Phil is accurate, then it says what it says. And we're slightly bound by it.
Yeah. We were about to the same self-same point that I had to make.
Well, my lord, that rather depends on how precisely you approach Milton Keynes,
Yeah.
and one may need to be a bit careful about taking it totally out of context. I mean,
what we haven't, as said, why are we looking for this purpose? This is a person's decision, which equating from a decision of our this.
Well,
If
perhaps we'll,
that extract is important, you should see Milton Keynes itself, so it's here.
well, let's go to Milton Keynes then. And the only reason I was going there was because the Divisional Court relied particularly on that bit of it.
What they should have said is we're bound by what Lord Justice Pill says, and this is the effect we take.
But of course, in Appellant, he was saying it doesn't really matter anyway, because
And Appellant was saying it doesn't matter anyway, but also you need to put next door to the Appel bit a bit of caution when you come to Judgment 181, because it isn't actually an accurate quote of what Lord Justice Elias does in fact say, which is the point I made earlier. But go to Milton Keynes for a moment, if you would. That's tab 23. And so, as paras 9 to 14 explain, starting on page 504, a consultation took place, and the case more broadly concerned a challenge to statutory instruments.
so which paragraph?
I'm starting at paragraph 9, but I was just giving you the context to frame it. The case concerned a challenge to statutory instruments that affected a change to planning legislation, essentially permitting the use of residences as houses in multiple occupation without seeking permission from the local planning authority. And there was a consultation, as 9 to 14 explain, that took place in 2010 on the change of policy, but only with certain key partners. And so that was the basis of the challenge.
Yeah, 17 is a good example. You said this has happened, like it starts in conflict and everybody afterwards just agrees.
Yes, and you get that from the Mrs. Justice Lang decision I sent you overnight that you were looking at as well, exactly the same. It quotes that bit from Mosley. That's from Cochran. You see the nature of the arguments that were mounted round about 29 and 30. And it doesn't look as though there was any real focus at all on the distinction between rationality on the one hand and fairness on the other. Fairness appears to have been the underlying assumption rather than anything. So the point isn't actually directly put as a point of choice in principle between those two. And then you get to paragraph 32, which is the bit quoted in para 36 of Appel, which proceeds on the basis, simply on the assumption that fairness is the answer. And all it says is he doesn't accept the submission that a decision maker can routinely pick and choose whom he will consult. Well, that may be entirely fair. And the second sentence, a fair consultation requires fairness in deciding whom to consult as well as fairness in deciding the subject matter of consultation and its timing, has to be seen in the sense of the arguments that were actually being presented. And there doesn't appear to have been any argument that there doesn't appear to have been any argument about rationality versus fairness. And the concern simply focused on, or appears to have focused principally on, whether or not reliance could be placed on the Buckinghamshire case, which is referred to in the submissions at paragraph 29. So it's not actually an authority.
It is Mr. Moore's submission, which was rejected, was that the decision maker can decide, in fact, that just means absolutely
Without control.
Who to consult, the question of what the nature of the control would be, which or rationality isn't an issue.
My lord, yes, and that, in fairness to Lord Justice Pill, he doesn't seek to grapple with the rationality versus fairness dichotomy, because it wasn't being presented on that basis, so he simply assumes it's fairness and rejects the Buckinghamshire submission, if you will. It's also to be noted that 32 is obiter anyway, not that matters terribly, because there's obiter and obiter, as we know, but it's obiter anyway, because in paragraphs 33 to 38, Lord Justice Pill explains why the Secretary of State was entitled to consult narrowly in this case anyway, so it doesn't really matter. But my point is that it isn't squarely confronting the position, and if I may respectfully say so, nor, if we can go here next, did the Court of Appeal squarely confront this issue, I fully accept, in Article 39. There is an en passant reference in the judgment of Lord Justice Baker, as we'll see, to rationality, so in my favour, as it were, if I'm jumping on bandwagons, but not squarely addressed as a point of principle. Article 39 is at tab 37. Yes, I'm sorry, it was Lord Justice Henderson who was the third member of the court. I've forgotten. And this, as you will recall, or at least one of my lords will recall, was a challenge to secondary legislation which sought to amend a series of regulatory protections in the anxious context, no doubt, of children's social care services due to the COVID pandemic. The government had consulted, and had actually accepted that it had consulted various bodies on the proposed changes, but had not consulted the Children's Commissioner. The Administrative Court had dismissed the claim on the basis that whilst there would ordinarily have been a duty to consult the Children's Commissioner, the exigencies of the pandemic meant there wasn't a duty in this case, and the Court of Appeal allowed the appeal and disagreed. The treatment of the law of consultation is dealt with at paragraphs 28 to 37 with quite a lot of citation of authority, including some of which will be familiar because we've gone to it already. And then picking it up after that introduction in the discussion and conclusion section of Lord Justice Baker's judgment, which begins on page 924, we can perhaps pick it up at paragraph 82, where the court concludes that the duty to consult arose in three ways. 82, my lord, sorry, on page 925.
Thank you.
So there was a duty to consult there which was statutory in nature, as you see from 83. Second sentence, it's correct that the subsection merely requires him to consult any persons he considers appropriate. But given the scope of the amendments arising here and the fact that the Secretary of State chose to conduct a consultation, albeit informally over a limited period, it was, in my view, irrational not to include the Children's Commissioner and other bodies representing children's rights. So the conclusion appears to have been that in the context of a statutory duty to consult, where the obligation is in fact imposed to consult, but nevertheless it's cast in terms of consult who have you considered to be appropriate, then the test is whether or not a rational judgment has been made. And of course we're dealing here with voluntary consultation, whether that makes a difference at this stage because we voluntarily consulted a group. Query whether that should lead to some different standard or test to the one that was applied by the court there may be questionable. But again, I fully accept that this judgment doesn't seek to confront the issue of principle directly, and there are references in it, including in particular in 85, the third of the three ways in which the duty arose was based on conspicuous unfairness. But that was a freestanding basis for concluding that the duty to consult arose. Having decided to do a consultation, there was no reason advanced at all as to why it wasn't done in that way or why it couldn't have been done that way. No good reason. Very good reasons why it should have been. That's the essence of the court's reasoning at 85. So you've got a few cases, both at Court of Appeal level, not quite doing the direct addressing of the question of principle, if I'm allowed to put it in that way respectfully, because I didn't need to in either of those cases. You've then got Lord Justice Elias, and apologies that I've gone to it out of order, but I went to it because they placed such particular reliance on what he'd said, the Divisional Court did, and they didn't actually accurately quote what he'd said or what authority he derived even from that earlier Court of Appeal case, the Lord Justice Pill one. But so the position is not finally cleared up. And of course, I accept that ultimately it may, in a lot of cases, it may not make a whole heap of difference. I mean, if the court reaches the conclusion that there really is no good reason, e.g. for not consulting the Children's Commissioner as there, then a rationality finding would follow as night follows day just as much as an unfairness finding or a conspicuous unfairness finding. So it may not make a great deal of difference in all cases, but it is important that the standard should be set aright. Can I make submissions? Yes, I'm sorry, my lord.
Paragraph 35 does seem to support
Of
the rationality point of Article 39.
I'm so sorry, I pushed away.
Just get your submissions on it. This is where he refers to the wrong case.
I'm sorry, I'm taking up the wrong file. So we're back in Article 39.
Yeah. And it's just paragraph 35, but it's just on this point. Once a duty to consult has been found to arise, it's for the decision maker to determine who should be consulted. The determination open to challenge on grounds of
Yes, my lord, I'm so sorry. Yeah, you're right. I referred you to the compendious paragraph.
It's not really clever, it's just, it comes from your skeleton.
Yeah, no, thank you. Well, my fault. Yeah, and cites Liverpool. Yeah.
And do you say that's the appropriate approach?
I do. That's my submission. I make the submissions a principle.
And why do you say it shouldn't be fairness?
My submission is that the common law, you start from the position where the common law specifies only very limited circumstances in which fairness itself will require a person to be consulted. So go back as a starting point to the basic duty. You'll remember Plantagenet Alliance, that very narrow category at the end. It requires a very high level of unfairness before it will impose a duty to consult on any particular person. Where the common law does not require a person to be consulted, brackets, voluntary consultation, and there's no statutory obligation, the decision maker has a choice as to whom to consult, is my submission. And that choice should be, on principle, susceptible only on grounds of irrationality.
What is the principle? This stage of the argument, the conducting consultation by the court in terms of fairness requires surely your decision should be both fair and rational. And you may have very high margin of appreciation in judging what fairness requires and what's equivalent to the wide margin of appreciation of some rational reason. But why couldn't it be both?
Well, my lord,
Often
may not make any difference.
Will answer the other, but
Doesn't matter. My answer to that is that if you're on the stage of doing voluntary consultation, has been characterised as voluntary consultation, that in itself is a choice. It isn't one of those. It isn't one of those areas in which the court has decided that you really must consult a particular group of people. So you've just simply chosen to consult. And the true analogue or parallel in public law terms in that situation, without the engine of that driver, the true analogue is in effect that the government is gathering information. It's a Thameside thing. It's the government's choice as to go out there for voluntary consultation to speak to a particular group of people to get their view, and it's for it to decide how it gathers that information, how it goes about doing it, and including in particular who it should go to for that. The analogue is in all circumstances where the court doesn't impose the duty on them for fairness reasons, it is the government choosing how to go about the business of government. So the true analogue in that situation is Khatun. It's Lord Justice Laws in Khatun, Khatun.
Which is a gloss on Thameside.
Which is a gloss on Thameside, and I just want to take you to that very briefly to remind you of it. Again, it's been cited and approved in lots of different ways in lots of different cases, including, I think, by.
Just before we get
there,
I mean, you say the underlying point is this is different from other consultation situations because government shows itself in the first place. There is nobody has really articulated the theoretical basis of the mantra which starts in Cochrane, referred to in the Article 39, where it was, not Article 39. But anyway, the allocation we've seen, once you do it, you'll be fair.
Once you do it, you've got to be fair. You've got to do certain things.
Yes, okay.
In other words, gunning things. It's not a big, broad fairness immediately obligation.
Yes.
That's perhaps
why do you have to do gunning things once you've chosen to consult? What's the interest?
Well, because then you've got the content of the thing, the manner in which you go about doing it. It's not as broad as who you go and speak to. I mean, there are differences there. There are distinctions there, I submit. It doesn't follow just because, and indeed there may be distinctions that.
Yes, I was trying to articulate. Suppose you voluntarily decided to consult with A, B, and C.
Yeah.
And you do it shoddily, but you never had any duty to do it in the first place. Whose interests are affected by your doing it shoddily? People with whom you did consult.
Well, my lord, that's a big debate, and it's a debate of the kind that we had before we were arguing Evely, and no one has yet gone there. I mean, it's a perfectly fair question, but no one has yet gone there. I don't propose to go there in this appeal. I may yet be troubling with you in the future.
Find us wanting to pick on points we don't.
No, but and I don't think you need to here, because you can look at it by reference to what you were doing in Article 39, for example. I mean, in Article 39, it was approached on the basis that if you have a statutory provision that says you must consult,
That's very.
but you don't automatically go, you must consult, therefore it's fairness. It's a statutory discretion, but you must consult, therefore it doesn't automatically lead to fairness. So one's teasing out where the boundaries lie of who is the primary decision maker.
Anyway, you're going to take Khatun.
I was going to take you to Khatun because I say that Khatun is the correct analogy here. When you're voluntarily consulting, you decide who you're going to go to. So Khatun is in tab 19. So context doesn't really matter. The court considers potential sources of obligation at paragraph 23. And as I say, this is all in the context of Thameside, what the standards are and how it all works. But the key bit, over labouring it, the key bit starts at around .34. So it's really that famous passage from Lord Scarman citing Justice Cook in Creed NZ, and then what Lord Justice Laws derives from that at paragraph 35. I think essentially exactly the same reasoning appears in the judgment of Lord Hodges in one of those Heathrow cases, citing this with approval. I invite to read 34, 35 and 36. So you've got a situation in which when the government is deciding what information to gather, how far to chase down a piece of information, how far to chase down a line of inquiry, what information it needs for the purpose of informing itself so as to make the best decision it feels it's able to. That's the Thameside duty. How does that work? It works on the basis of rationality. And my respectful submission is that that's the true analog when you're dealing with a situation like this, where you're not under an obligation to consult, you choose to consult. Who you consult should, I respectfully submit, in just the same way, and because that is the true analog, be a matter of rationality for the decision maker. And indeed, one can look at it from a slightly different perspective, because the Divisional Court appear to be doing a kind of comparative exercise. Someone's being disadvantaged, but of course, those who aren't consulted being in some way disadvantaged or treated unfairly or something. But the fact that you consult only a limited number doesn't give anyone else a legitimate expectation or anything else that might trigger fairness. But as importantly, if the conditions for the imposition of a duty to consult public law are not met, then the public authority is not obliged to consult B merely because it has consulted A. There isn't a parity of treatment principle at public law that drives any such conclusion. And indeed, we know that Gallagher in the Supreme Court explains that there is no principle of equal treatment in domestic administrative law. Gallagher, I'm not going to invite you to turn it up now, they're well-known passages, authorities, tab 34, page 789, the key paragraphs are 24 to 28 in Lord Carnwath's judgment. And as he points out there, you haven't got a principle of equal treatment in domestic administrative law. What you do have sometimes is issues of consistency arising, but they arise as issues of rationality. So if you can't claim parity of treatment as the basis for the imposition of some broader fairness standard. So for all of those reasons, we submit rationality is the key, and rationality is the correct approach in principle, and there can be nothing irrational on that basis in consulting those who were in fact consulted or engaged with.
No, I think they put it not that it was irrational to consult the police. They say it was irrational to consult the police and no one else on the other side.
Yes, but that's why I was referring to the parity of treatment approach.
Well, they don't say for parity of treatment, but just once you've engaged in a fair consultation, you can't just consult one side.
Yes, but it proceeds on the basis. All at the moment I'm addressing is the issue of standard.
Right.
So it's rationality, not fairness. I'm coming now to no unfairness, no irrationality. The 183, the judgment 183 points. The first thing to note about this is the reliance on the committee report, which was at its highest in this part of the judgment. It relies on that committee report as instructive at 182. It endorses the conclusion of the report at 183 Roman 5. At 7, it expressly agrees with the conclusion of the committee report, and at 8, it relies in support on the committee report. So we do not accept Liberty's skeleton at paragraph 65, which asserts that on a fair reading, the Divisional Court was not attributing any analytical weight to the committee report. It plainly was, as a matter of fact. We respectfully agree with the Speaker's written submissions in relation to this part of the case, including their reference to Mr. Justice Stanley Burnton in Office of Government Commerce and the Riley case, as 25 to 27 of the Speaker's submissions. And we respectfully agree with the conclusion that is reached there, which is that it is not an appropriate thing for the court to have done, to have relied upon the committee in that way for reasons which are well rehearsed and clear.
Was that because it's a committee rather than the all-party parliamentary group? Because there were issues raised about Article 9 with the TERIC reports on the all-party parliamentary group.
And they had a slightly different.
They then decided that you could look at the underlying material given by the scientists, but not the conclusion.
Yes, well, it ends up in sometimes in slightly odd places where you can refer to Q&A sessions that happen with government before the committee,
Yeah.
or evidence submitted into a committee, but you can't rely upon the conclusions of the report. But I think the explanation for that is that the vice that is being protected against is the Article 9 vice, which is questioning proceedings in Parliament. And if one party, as it were, or the court or someone puts in issue a critical conclusion, that's different to the underlying evidence. So there are also lots of questions that sometimes arise about whether reports of particular people are to be attributed to Parliament for that purpose. But that again is a separate set of issues. But I think the core vice, and really this is what we're talking about here, but the core vice is relying on adverse comment or statement in a parliamentary committee report, because that forces one side or the other to, coincidentally it's quite often government, to take a view which is different from the view expressed by the committee in Parliament in judicial proceedings. So that's the initial concern. I wanted to focus in particular on the factors that the court relied on below in applying what it described as its broad standard of fairness. So 1831, proposals assumed an increased exposure to criminal sanction. That is identified as a freestanding reason for consulting people who might be adversely affected. It doesn't seem to depend in any way on the fact that there was in fact engagement with police bodies. But the answer to that is that the mere fact that someone might face the risk of being adversely affected in the future by a legislative change has never been a sufficient reason to impose a duty to consult that person, whether as a result of fairness or otherwise. See Bappio. Also note, on the logic of that reasoning, you'd have to undertake a full public consultation rather than a more limited exercise. No rationale is given for a more limited duty of consultation to any certain representative people. It would have to be a public inquiry, a public consultation. The court.
So, sorry, is this by way of observation on 1831?
Yes.
The proposal assumes an increased exposure to criminal sanction.
Exactly. So what they do is to say, look, the government's own figures show there might be an increase in prosecutions as a result of this. And because more people might be prosecuted as a result of this, that's a good reason for consulting those other people who might be prosecuted. And my answer to that is that the mere risk of being prosecuted in the future by a legislative change if Parliament chooses to make it, it has never been the basis for a duty to consult or a ground for saying, in fairness, you ought to or have to. See Bappio. And the second point I was making was that the logic of that, in any event, it almost proves too much, because you're going to have to undertake a full public consultation, because everyone might be prosecuted, everyone potentially is a protester or a demonstrator. I'm not going to spend too long on it, but we would invite you to have a bit of a look, if you're considering that paragraph, at the economic note itself. And I think this paragraph puts it on the basis that the government was aware that this was likely to increase the number of conditions imposed by police by up to 50%. Prosecutions would increase by circa a third. That's not quite a fair recitation of what the economic note actually does. It's at, I'm not going to take you to it now given the time, but it's at tab 31 of the supplemental bundle. And we'd invite you to particularly note the first page of the note, which confirms that it hasn't been possible to estimate the exact number of additional criminal outcomes arising from the measure, page 230. And the assumption, and it is an assumption at paragraph 52 of the economic note on page 240, is of between a 20 and a 50% increase with a central estimate of 35. That's more for completeness than anything else. My answers are principle I've given. Sub 2 is fundamental common law rights were engaged. Now, that might well have been a reason for Parliament to impose a consultation obligation if it chose to, but it hasn't and didn't. It's not enough to impose a duty to consult at common law that a general measure might in future adversely impact someone's fundamental interests. It doesn't work even if they're potentially exposed to criminal sanction. It certainly doesn't work if their interests are engaged. And in any event, the impact on fundamental rights is, we respectfully submit, overstated. Sections 12 and 14 of the Act are not concerned with banning processions or assemblies, only with imposing conditions relating to, for example, the route. They also only confer on the senior police officer a power to give directions rather than a duty to do so, and that exercise of power can be subject to JR. Moreover, Parliament has retained a degree of control by reason of providing for regulations to be subject to affirmative resolution. 12 sub 15 and 14 sub 15, as you will have seen. And moreover, Parliament has required the Secretary of State to prepare and publish reports on the operation of the amendments to section 12 and 14 and to lay the report before Parliament. That's in sections 73.5 and 74.7 of the Police, Crime, Sentencing and Courts Act of 2022, Authorities, tab 2, pages 10 and 14. And the final sentence of this bit refers to, seems to raise a parity of treatment complaint. The views of those negatively affected by enforcement suggests that anyone who could be conceivably subject to a condition. But
am I right in thinking like this is that we don't have a firm technical process as to who should be consulted?
yes, I think there's a suggestion somewhere in the judgment, I may get to it, but there's a suggestion somewhere in the judgment that it doesn't have to be everyone, it can just be representatives of, or interest groups or whatever.
Yes, but which interest groups?
Well, there's a big question. There's a big question. The question is, even if you identified all of them, would that be sufficient? Because some protester might say, well, I'm not interested in them representing my views. And you slightly drift back at that point into all those worries that Lord Justice Sedley was expressing in Bappia about how you actually go about defining the obligation. Who is it that you have to consult? Again, I didn't take you to it, but it was picked up particularly in Lord Justice Morris Kay's judgment in Bappia as well. That same idea, you've got to be able to define the obligation with precision, otherwise it doesn't work. Anyway, that's Roman 2. Roman 3, readily identifiable class of adversely affected bodies and persons. Even if that were correct, it would not be a reason why common law fairness requires any person particularly to be consulted. The mere fact that you can readily identify a class of adversely affected bodies or persons. But we note that in the economic note, to which they've made earlier reference, at supplementary tab 31, page 232, there is a list at A4, capital A4, which includes the general public, in inverted commas, protesters, road and other transport users, and witnesses of disruptive protests. In any event, we do submit that the class who have got to be consulted, would have to be consulted, is not sufficiently identified by the court. You can't just say as they do. We don't suggest that the consultation would necessarily have to be open to all wishing to respond. Obvious candidates will be representative groups and so on. Yeah, that's the point. if fairness is an issue for the court, then the court has got to be able to identify with precision who had to be consulted so as to discharge the obligation. I refer back already to the concerns expressed by the Court of Appeal in Bappia about the court imposing uncertain duties of consultation. 183.4, stage of development. Again, that isn't, we submit, a reason why fairness requires consultation. And saying, as they do in the third sentence of that, the point at which the executive engaged with the police was late in the process and views were sought on precise drafting issues, that misses the point, that the process which was undertaken couldn't reasonably have been extended to third parties. It would have needed an entirely new and different consultation process, which would have had to have been undertaken. And we do note that the authority we handed up overnight, I won't go to it, but the paragraphs we gave you are an example, at least, of a case in which the court held that there was no consultation to consult more broadly after an in-principle decision had already been made and when you were just working through the mechanics or details of things.
I haven't got authority.
Don't worry. I know Lord Justice Dingemans does. Can I hand up two in case? I'm not going to take time on it because I'll need to finish, but we gave you the paragraphs overnight. It's on its facts, but it's a useful little section. 1835, scope of issues and ability to improve the quality of legislation. That may or may not be right, but the fact is that that has nothing to do with why an omission to consult a particular group or the general public was unfair as a matter of law. They weren't entitled, the Divisional Court, to intervene on the basis that a consultation process could have improved the quality of legislation. There's no maladministration ground. It's for the government to decide and Parliament to decide what it needs before it legislates. And of course, bear in mind with all of this was in the context of clauses in the bill, which didn't become an act. And we object to the reliance on the Scrutiny Committee's report in Roman 5. Roman 6, conducting a broader consultation exercise would not have been onerous or disproportionate. Again, not a good reason or any reason why fairness requires consultation. Fairness does not require everyone to be consulted, save where it would be disproportionate to do so. And it's also unclear what broader consultation exercise the court had in mind. I mean,
most of the later points made here are really not reasons why fairness did require it, but simply reasons why the absence of any possible objections, potential objections, like it wasn't too late.
yes.
It wouldn't be too difficult. But you say
You've got to
find an obligation in the first place.
yes, and you've got to do it to one of the standards we're thinking about. And the standards in the game on the standards is rationality, conspicuous unfairness, or just broad standard of unfairness. But I respectfully agree, whichever one you go with of those, even if you go with the general standard of fairness, you've got to still identify why it is unfair not to consult that particular group. And I'm not going to keep going through them all. My Lord has those points. So I'd just be repeating, as it were. None of them provide a ground for saying it would be unfair. And the stand-back point is, go back to the facts. I mean, the facts are that you've seen the nature of the engagement. You've seen who was consulted or engaged with at that stage and for what purpose. You've seen that is absolutely bog standard government business to consult and get the views of those, particularly those most directly affected people who will have carriage of the thing if it goes through and who have had experience of it in the past. And if that is enough to create a duty to continue to consult others, including effectively on the logic of this reasoning, the entire general public, then there will have to be a consultation every time any serious proposal is advanced. That's the real concern to which this judgment gives rise. Coupled with all of that, we respectfully submit, is the point that if Liberty had complained of a failure to consult at the time the engagement happened, the court simply wouldn't have recognised any duty to consult and wouldn't have afforded any relief anyway, because this was in the context of proceedings in Parliament. So we do submit that, leave aside that constitutional reason, which is important in its own right, the broader point of principle, which is a really significant broader concern here, is that the logic of this reasoning is simply untenable, we submit, and would create very, very serious difficulties of precisely the kind that Lord Justice Elias noted in Appellant. My lords, those are my submissions in opening.
Thank you very much indeed.
My lords, I'm going to develop the argument on ground one, vires ground. My learned friend Miss Higgins is going to pick up the baton tomorrow morning and address consultation. Ground one in our respectful submission arose as a vires challenge, and analytically it involves asking two questions. The first question is, what did the regulations do? And the second question is, was that something that Parliament is likely to have delegated to the executive?
Likely to have.
Yes, was it within the
Why is that the main question?
well, was it within
Did
what?
it?
Yes, was it within the class of action that Parliament must have contemplated when enacting the provision itself, Section 1212? There are simply two ways of putting the same point. And we say the answers to those questions are obvious, and I'm going to structure my submissions by answering them first and then addressing the
Sorry,
Henry
can I
VIII.
just have two questions again?
What did the regulations do? Was that within the class of action that Parliament must have contemplated when enacting Section 1212?
Why do you put the second question that way? Why did you ask, was that within the class of actions that Section 12 of its crude construction authorised?
Yes, well, but
Well, it's not like contemplation, it seems to be rather woolly.
well,
It's a reading.
yes, it's a simple question of construction, and we say that Parliament's intention wasn't to give the meaning that Sir James suggests. But to answer the first question is that the regulations changed the meaning. So they changed the meaning of serious disruption to the life of the community, and they thereby lowered the threshold for criminal conduct.
Sorry, I didn't. So the first question, what did the regulations do? What, yes?
What the regulations did is they changed the meaning of serious disruption to the life of the community. And in so doing, lowered the threshold for criminal conduct. Then to answer, my lord, the second question about statutory construction, we say that Section 1212 was intended to permit the Secretary of State to clarify, but not to change, the meaning of serious disruption to the life of the community. We say that simply as a question of statutory construction. That reflects the words themselves, the context, the wider statutory context, and the admissible aids. And then, having answered those two questions, my lord, there is a final line of authority which conclusively answers this appeal. and that is the case law on the Henry VIII powers, and in particular the judgment of the Supreme Court in Public Law Project, which Sir James simply didn't raise. So that's the structure of the submissions. Can I turn to the first of those points? What did the regulations do? And the answer to this is actually in my learned friend's client's explanatory note, which is right at the end of the supplementary bundle at tab 37, page 325. Supplementary tab 37.
Appeal bundle or authority bundle or the appeal bundle?
Supplementary appeal bundle, I'm so sorry.
Yeah, tab 37.
Tab 37, yes. So as my lords will see, 7.10 on this page explains the concept of threshold for examples of cases which may constitute serious disruption to the life of the community. The amendments changed the threshold for when disruption should be considered to constitute serious disruption to the life of the community in list of examples. From significant delay and prolonged disruption to the prevention of or a delay that is more than minor to, and the prevention of the disruption that is more than minor to, as well as making clear that this may be by way of physical obstruction. And so the starting point is that the Secretary of State's case is that these regulations lowered the threshold for when conditions can be given. And that's why we say the Divisional Court was completely correct to start its analysis by asking what serious disruption meant. And the Divisional Court's ultimate conclusion was that serious disruption had a high threshold. My learned friend doesn't challenge any aspect of the Divisional Court's reasoning on that, but simply says that's the wrong starting point. And we say that starting point was the correct starting point analytically, because it enables the court to assess what the regulations actually changed. And so we say there are 7 points which explain why the Divisional Court was correct to find that serious disruption to the life of the community had a high threshold. The first point, which the Divisional Court set out in its judgment at paragraph 55, is that the context here is common law rights. And my learned friend effectively accepted this at the end of his submissions on consultation. Protest is a recognised common law right in and of itself. It forms part of the right to freedom of expression. And that's what Lord Chief Justice Burnett explained in the Richard Roberts case, which the Divisional Court cite. The second reason why the Divisional Court was correct is because the white paper, which introduced the Public Order Act 1986, made it plain that these provisions were intended to strike a balance between this fundamental common law right and the rights of the community, with the minimum impact on the right to protest. And the Divisional Court set out the key passages from the white paper in its judgment at paragraphs 58 and 59. And it is clear that from those paragraphs that serious disruption was intended to have a high threshold. And so my Lord Justice Dingemans asked the question whether or not the courts had considered that interpretation after it was brought in. But the white paper gives us a very clear steer in that direction. And if the court needs it, the court also has paragraph 4.11 of the white paper in the supplementary bundle tab 27 at page 186, which explains that serious, in the phrase serious disruption, was intended to represent a real distinction and an important safeguard.
Sorry, the reference again was?
The first reference was to the Divisional Court's judgment at paragraph 58 to 9. Then we have supplementary bundle tab 27, page 186, paragraph 4.11. And that's explaining what serious disruption meant in the previous part to ban processions. So that's the second point. The third point is...
The phrase, I can look it up, there are two phrases you picked out for a real distinction.
Yes, sorry.
And what was the other
A
phrase?
real distinction and an important safeguard.
Look it up.
Yes.
Yeah.
The third pointer towards the Divisional Court being right is that the context here is criminal. And so as the court will see from looking at section 12.4 and section 12.5a, someone who organises or takes part in a procession which is contrary to one of these conditions commits a criminal offence. And there is no reasonable excuse, justification for committing that criminal offence. So for example, I cannot say if I'm charged with a criminal offence under section 12 or 14, I was simply expressing my Article 10 rights.
Does it make a difference that the criminal context is, as it were, one removed? This is not defining something that creates offence. The offence is breaching the conditions. But it goes to whether the conditions should have been imposed in the first place.
Yes.
Doesn't that make a difference? Because the general rationale behind taking a very strict view of criminal liability, provisions imposing criminal liability, is that there shouldn't be any ambiguity about what conduct, if you choose to do it, will be criminal. Here there's no ambiguity because the conditions clearly expressed. The fact that arguably the condition should not be imposed in the first place is irrelevant to you knowing where you stand.
Yes, but because we are imposing criminal liability in a rights-related context, that's all the more reason for finding that threshold is high.
My point. You may be right.
Yes.
Is there a separate principle? Look, what's the principle that you're relying on? It's not that the citizen doesn't know what they should or couldn't do.
Well, the principle that we're relying on is that because this is a criminal context, and because Parliament was weighing a balance, then these are reasons why Parliament is likely to avoid that balance by putting in place a high threshold. And that's the extent of the submission, my lord. I don't take a doubtful penalisation point on this.
Yes, there is not a doubtful penalisation. I'm not quite sure what the point is. But you just say anything to be a crime, anything in a sort of chain of events which may lead to someone committing a criminal offence is a reason for taking a strict construction.
Yes, in part, but these points go together, my lord, because
No, I see
and
that.
they make sense in
I'm just
particular.
analysing them as they go
Yes,
along.
yes, and it
Okay.
makes sense in particular when read in the context of the white paper, because the white paper is saying we are only imposing criminal liability to the extent strictly necessary, because we recognise the importance of rights in this context. And so for those reasons, the combination of imposing criminal liability in a rights-related context is a good reason for finding that Parliament intended Series to have a high threshold.
Can I just ask a question? Regulation 12 gives the power to amend subsections 2A to 2C.
Yes,
2A to 2C came in 22 as well.
yes.
So does the white paper help us very much then?
It helps us in understanding what the regulations which are an issue in this appeal did. And so they help us in understanding that the regulations in this appeal had the effect of lowering that threshold which Parliament had deliberately set to be high. And when I come to the statutory construction argument, my lord, my point will be that Parliament is inherently unlikely to have delegated that power to the executive when Parliament itself set the balance in section 12 in the first place. Then Parliament again set the balance in section 12 2A to 2C. And so that's when we come then to section 12 and 14 itself, because when it was enacted, the words used were serious public disorder, serious damage to property, serious disruption to the life of the community. And that's the key phrases. Each aspect of those things informs the other. They're intended to be at the same level. And it is also clear in our respectful submission that the word serious was intended to elevate the threshold. And the Divisional Court set out in its judgment at paragraphs 51 to 53 the principle of statutory construction of the de minimis principle. So the word disruption, if it had been used on its own, would have intended disruption that was more than minor. Therefore, the addition of serious to serious disruption must have meant something different to that.
Is minor the same as de minimis?
I'm just going to turn up the Divisional Court's judgment. It's tab 5, page 41. And so the Divisional Court started by setting out at paragraph 51 the principle of de minimis. The law does not concern itself with trifling matters.
It's not 51.
Yes, it's page 41, paragraph 51.
Yes.
And so Parliament's, or the Divisional Court set out the principle. The law does not concern itself with trifling matters. Then at paragraph 52, it applied that to the expression serious disruption. And it concluded that if Parliament had simply used the word disruption without the qualifying adjective, a de minimis threshold would nevertheless have applied, so that interference of a minimal nature would not, in law, qualify as a disruption. And minor or minimal is the same word, my lord.
Sorry, say it again?
The words more than minor and more than minimal are directly the same words.
I'm not sure that's right. I mean, minor and minimal don't mean the same thing, do they?
Well, my lord.
I won't go back to the Latin, but
Well, I'm glad because I wouldn't be able to assist my lord with the Latin.
Well, minimum is a superlative and minor is a comparative.
Yes.
But forget all that. In ordinary language, minimal means very small indeed. Minor means small.
Yes.
So I'm just not convinced that you can equate de minimis with minor.
Well, this was one strand of the analysis, and as the Divisional Court noted then in paragraph 53, it was a strand of the analysis that wasn't actually in dispute. And so my lord will see that Sir James accepted. So the converse of serious as being trivial wasn't argued. And so there was a de minimis threshold, and serious was meant to raise this above the de minimis threshold.
That's a different point from whether common ground de minimis is de minimis.
Yes.
But
No,
minor may be higher than that, and that's not paragraph 53 doesn't address that point.
No, my lord is right, and my lord, the Vice President's point, which is that minimal and minor may mean something different, is also narrowly correct. And so I've set it out. That's the submission. The Divisional Court put that as one of the various reasons that it was drawing upon, but not the sole and conclusive reason. But of course, that interpretation is consistent with all of the points that I've taken hitherto, and also in particular with the white paper. It's also consistent with this 2022 Act, which my Lord Justice Dingemans has brought our attention to. And it may be worth turning that up, which is in the authorities bundle at tab 2, paragraph 9. Or sorry, tab 2, page 8. Because what the 2022 Act did was two things. First of all, it introduced section 2A to 2C. And my Lord will see that subsections 2A to 2C were illustrative examples of what would result from serious disruption to the life of the community. And so here is Parliament explaining what this phrase means.
Sorry, I'm just reading something else. Which one are we looking at?
Tab 2, bottom of page 8. My Lord sees section 3 introduced, subsection 2a.
Yes.
And can my Lord see, for the purposes of subsection 1a, the cases in which a public procession in England and Wales may result in serious disruption.
Yes.
And then my Lord will see over the page the illustrative examples that Parliament itself gave. Again, Parliament itself setting the balance. And so these illustrative examples included significant delay to the delivery of a time-sensitive product, prolonged disruption of access to essential goods. And our submission is that those adjectives maintain the high threshold which Parliament originally intended from the phrase serious disruption to the life of the community. So it's not just any delay or a more than minor delay, it's a significant delay and a significant delay to a time-sensitive product. And it's not just prolonged disruption, it's prolonged disruption to essential goods and services. And Sir James suggested that these things were within the range. We agree. These are within the range of what serious disruption to the life of the community means, but they are at the high end of that range. And so this is Parliament itself setting the balance, and again setting the balance at a high level. And so that is number one, it's important for understanding what the regulations did, but it is also an important place to start when we look at the statutory construction issue, because this is the same statutory provision which introduced section 12.12 and section 12.13. And this is what Parliament was intending by the section 12.12 and 12.13, is amending those illustrative examples for the purposes of making provision about the meaning. And so again, that's an important pointer we say. It says the Secretary of State may, I'm just going to read what subsection 12 says. It's just at the bottom of page 9. My Lord, the Secretary of State may by regulations amend any of subsections 2a to 2c for the purposes of making provision about the meaning for the purpose of this section. And so that's...
I'm so sorry, I thought you were still on 2A.
Yes.
You're on now 12.
Yes.
Okay, right. Thank you.
And so again, what we have here is the 2022 Act introducing illustrative examples and then giving us a Henry VIII power to amend that list of illustrative examples. And of course, some of those illustrative examples going back to them are themselves technical. So what is a time-sensitive product? Is something which is liable to change as technology develops. How much delay is significant in the context of a time-sensitive product? Some things are capable of being reduced or expanded. Society's view of what is an essential good and service might change as time passes and as technology develops. And so again, these are technical words which are intended to be readily understood by people on the ground, police officers issuing conditions, protesters seeking to protest. And Parliament may well have considered that those terms, which are technical terms, were capable of further.
So which are the technical terms?
So going back to subsection 2a, and then it's example A afterwards, it may result in a significant delay to the delivery of a time-sensitive product. Time-sensitive product. What does that mean? Again, then...
It's not, well, I suppose you could say it's technical, but I mean it's something you need to know the context for.
Yes.
I think that means it's technical.
Well,
it's a significant delay, certainly technical.
No, but
what
the
problem might be, if I was a police officer, I'd say what counts as significant?
Yes. Well, this is part. We say what counts as significant is the same as serious disruption in any event, but also the word time-sensitive product. What society views as a time-sensitive product is something which is liable to change, whether that's technical or not. something which is time sensitive may change. Equally so too, what is an essential good and service? And examples are given there. Society's prioritization of those things, again, may change. And so that's a further pointer towards what the Henry VIII clause means. And so that's the fifth reason why we say that the Divisional Court was clearly correct to find that serious disruption to the life of the community had a high threshold. And the next reason, the sixth reason, is that serious disruption, or serious for when it's used as a qualifier, had a recognised meaning in the case law, as the Divisional Court explained. And this is paragraphs 44 to 48 of the Divisional Court's judgment. And the court went through a series of different contexts. The first is Birch, which is a hospital order case. And that's what does serious harm mean in that context. And for the court's reference, the page in the authorities bundle is tab 10 of volume 1.
The references to the...
This is for Birch. If the court wants to turn it up, it's tab 10 at page 145.
Yeah, I was just after the reference to the Divisional Court paragraph.
Oh, sorry, it's paragraphs 44 to 48. And so the
I'm not saying you're wrong.
It's just I can't find that. Are you sure you've got the right reference? It must be 48 onwards, I think.
no, my lord is right. I've got the wrong reference.
No, don't worry. It's just I couldn't spot it. That was my problem.
It's actually paragraph 60 on page 44. Sorry, page 44. Page 44 to 48 rather than paragraph 44 to 48. I'm so sorry, my lord.
Okay, so it's basically 60. It's all those cases. That
All of those cases, yes.
All the well, for serious, it's the cases go down to 65.
To 72, really, I think is
Yes.
Yes.
Well, 72 is about some of them about substantial.
Yes. Some of them are about serious, some of them are about substantial. And what the Divisional Court takes from those cases is at paragraph 72. And that conclusion, which is an orthodox statutory construction approach to the word serious, was, in our respectful submission, clearly correct, and reflects, as it does, we know, the explanatory note with which I started.
You say it's orthodox, it may be orthodox, but I just want to be clear about that. None of the cases about serious, what the word serious means, are in the context of the 1986 Act. They're a completely different context.
They are. Well, perhaps the most analogous context is the Defamation Act context, because that's a context in which Parliament is, by statute, interfering with the common law right to freedom of expression, and protest, as we've seen from the Lord Chief Justice in the Richard Roberts case, is an interference by Parliament with freedom of expression. And so that's the height of it, but it's all of those things. Yes, yes, it's
by heightening the bar at which you could intervene. What it was interfering with was the Article 8 right, for the common law right to reputation. So I'm not sure it is analogous.
It's analogous only insofar as Parliament is striking a balance between freedom of expression rights and other people's rights. And again, that point in and of itself may not clinch the Divisional Court's finding, but it's all of those points taken together which leads to the clear conclusion at paragraph 72, with which Sir James doesn't ultimately quibble.
You may not accept the premise of this, but if the premise is right that the word serious can have a variety of different flavours depending on the context. It can mean, at the very least, more than Dingemans, as an example for that. It can mean, without any context, more than minor. Indeed, it would be odd if it couldn't, because the 2013 Act uses more than minor. and then it can mean some higher threshold. Very difficult because none of these things are measurable, but some higher threshold than merely more than minor, which is after all what you're arguing for, what the Divisional Court found. So if the question is what does it mean in the 1986 Act, part of Europe, does it help to look at what it means in other contexts? It's always contextual, isn't it?
Yes.
So the case law about defamation or case law about
Hospital orders or
serious damage,
misconduct,
criminal
mental illness.
offences, those really help, do they?
No, they simply all they do is they give examples of serious meaning something at a high
Yes.
threshold.
But unless you could go so far as to say whenever the word serious is used in common law or in statutes, it always means a very high threshold. Then you're overdrive because part of using an accepted term. But if you're just using a term which is inherently ambiguous or covers a range, perhaps, we've really got to look at how it used it at the context of this particular legislation. Nothing else will really be relevant.
Well, the relevance of the other examples are of courts ascribing a high threshold to serious in those contexts. And that's the extent to which they genuinely assist. Another example is in Sir James's new authority, the transactional case, which he's handed up to the court today, Mrs. Justice Lang's judgment, because she in that judgment, paragraph 175,
175.
yes, refers back to the Divisional Court's judgment in our case as setting out an established dictionary definition of what serious means. And so what we have from all of these different contexts.
Why are we doing that? We've written that in our own judgment.
Yes, well, it's simply saying, I'm simply making the point that our own judgment has been approved by Mrs. Justice Lang in this case. And so we have a stream of cases, all of which lead to the same conclusion of serious being at the high end of the threshold. And that's why the Divisional Court was right in saying that Parliament did ascribe a particular meaning to serious when introducing the Public Order Act. And that's why the explanatory note is also right in recognising that the regulations changed that meaning. And so to make that point good, we look at what the regulations did. And so we haven't really looked at this, but if my lord turns up tab 4 of the first authorities bundle.
Sorry, we asked you questions. You said you had 7 points.
Yes,
the 6. Is this your 7th?
No, the 7th was the dictionary definition point.
Oh, right, sorry.
And so the combination of all of those 7 points leads to the same conclusion. And that brings us to what the regulations actually did. And my lord sees this in the authorities bundle at tab 4, which is the Public Order Act as it now is. And so the old subsection 2A, introduced by Parliament itself in 2022, has been changed by secondary legislation in the way which is set out at page 26 of that tab. So the prevention of or hindrance that is more than minor to the carrying out of day-to-day activities. And so whereas Parliament itself struck the balance high, with illustrative examples which themselves were high, serious disruption to the life of the community, which is that phrase, now includes at subsection 2A, Roman numeral 1, the hindrance that is more than minor to a single journey. And that is, on any view, a significant lowering of the threshold. more than minor hindrance to a single journey is not what Parliament plainly intended in the 1986 Act by serious disruption to the life of the community. And again, whereas we had significant delays previously to time-sensitive products and prolonged disruption to essential goods and services, it's now more than minor delay or disruption to any day-to-day activities at all. That's subsection 1 as well. So more than minor hindering of any day-to-day activity is now sufficient to have a condition. And my lord, that's why we say it's not credible to suggest that this is anything other than a change to the previous law by lowering the threshold which had been approved by Parliament for police intervention. We have gone from a situation in which serious had a heightened meaning to that situation being removed, and the word disruption effectively on its own being introduced in its place. And that, of course, again, will have an impact on common law rights. It will have an impact on the number of prosecutions. It will have an impact on the number of conditions. And all of that is reflected in the economic note that my learned friend Sir James brought the court's attention to. And in particular, if the court turns up the supplementary bundle tab 31, page 258. This is the supplementary appeal bundle. And the court will see when it comes to read this in detail that the economic note is predicated on there being more magistrate courts cases, more legal aid costs, that's paragraph 54, and greater prison costs, that's paragraph 55 and onwards. So when those aspects of the regulations are added together, where we are left is a significant lowering of the threshold and a significant increase in the likely level of criminal conduct. And so the question for this court is whether Parliament intended those things when it introduced section 1212 and section 1213. And that brings me to the second stage of the argument, which is a simple question of statutory construction. And again, if we could go back and look at the 2022 Act and what it was intended to do, at tab 2 of the authorities bundle, page 9 and 10, the wording itself is the Secretary of State may by regulations amend any of the subsections for the purpose of making provision about the meaning for the purpose of this section. And again, that suggests that the words serious disruption to the life of the community had a single meaning, and the provision could be made about it, about that meaning, not a change in the meaning or a creation of a new meaning. And realistically, as a matter of natural and ordinary language, the words making provision about the meaning of a concept refer to the provision of the explanation or elucidation of its meaning, not to a provision that replaces that concept with a different one. And that submission applies all the more where Parliament has enacted a statute that sets the boundaries by reference to certain concepts and then authorises the Secretary of State to make provision about the meaning of those concepts. The overwhelming likelihood, we say, is that Parliament intended that power to be used for the purpose of clarifying the framework rather than the executive remaking that framework or reconfiguring that framework. That submission applies also to the ordinary reading of paragraph 13A. So defining any aspect of an expression. Defining something, again, implies that there is one definition. it is different to a redefinition or to a change in the definition. Again, Parliament is legislating on the basis that it is the primary lawmaker, that it had come to a view on what serious disruption to the life of the community meant, and that that view was expressed in the words of sections 12 and 14 as we've looked at them. Sorry, my lord. The next pointer when we're looking at the language of the section is the points that I've made by reference to subsections 2A and 2C, which subsection 12 is expressly tethered to. Subsections 2A to 2C were illustrative examples. They weren't redefinitions or changing in the threshold. And so again, what Parliament is likely to have intended by using the words by tying this power to subsections 2A to 2C is explaining the illustrative examples, giving other different illustrative examples, but still at the same high threshold of seriousness. And that submission applies because, well, perhaps the adjective technical is the wrong term here, but because those phrases that are in subsection 2A to 2C are phrases which are capable of changing and are capable of different interpretations, particularly by the people on the ground, police officers and members of the public. The evidence of the intervener, in this case the Public Law Project, suggests that the normal and ordinary use of Henry VIII's powers is to provide an explanation of areas of operational detail. And again, given the wording of subsections 2A to 2C, which are questions of operational detail about what is an essential good and service, what is a time-sensitive product. Again, where we come when we look at simply the language of this section is the likely intention of Parliament is for these powers to be used for explanation, elucidation, illustration, not for fundamental redefinition. And again, that point is again perhaps put beyond doubt by subsection 13b, which again says, for the purpose of giving examples of cases in which a public procession is or is not to be treated as resulting in serious disruptions to the life of the community. Again, that's a further pointer towards what section 1212 means. It's a further pointer towards the kind of conduct that Parliament envisaged would fall within the exercise of this power. And so when we look at the simple wording of the statutory provisions, subsection 12 and 13, in their context of that section which introduced them in 2022, where we are left is that Parliament intended these powers to mean that the executive could illustrate, elucidate, or explain, but not to change.
Can I just ask a question of detail? I mean, the similar powers were given in relation to section 14 in the public assembly.
Yes.
Were they ever exercised?
I believe that they have been exercised, my lord. Yes, and
changes. It's exactly the same.
they're the same changes. The same changes were made to section 12 and to section 14, and they're in exactly the same terms.
Yeah, it's
And
regulation.
so I haven't taken, my lord, to those changes, but they are also in this.
It's regulation 3 at page 218 of the funding.
Yes, they're if my lord turns up, and what section 14 now says, which is in tab 4 of the bundle, page.
So, I mean, you also
Page 39. Yes, exactly. Yes,
I'm
I'm sorry. I've been doing that as a shorthand, but it's exactly the same power being used in exactly the same way in the two sections. And so that's the first point in terms of statutory construction, the words themselves. But that point is put further by the context. And the context, as we have seen, is that Parliament was initially legislating and continued to legislate in a context which was number 1, criminal, and number 2, rights related. And we say that that context means that, again, Parliament is inherently less likely to have left it to the executive to decide how that balance between different rights should be struck. If the context is technical or uncontroversial or about operational implementation, then yes, Parliament is likely to have left those things to the executive. If the context is criminal and striking a balance between the rights of the community and fundamental common law rights, then Parliament is inherently less likely to have been delegated those powers to the executive. A controversial issue requiring a decision of substance is something that Parliament keeps to itself. Sensitive issues involving criminal conduct and fundamental rights are inherently the kinds of things that Parliament can be expected to have wanted to retain control of. That's why it introduced Section 12 and 14. That's why it introduced the powers that we've seen in subsection 2A to 2C. And the rhetorical question which we could ask of Sir James is, what reason of principle is there for Parliament wanting to delegate to the executive the power to lower the threshold for criminal conduct in a rights context? And no such reason has been set out in the Secretary of State's written submissions or in the oral submissions. When we talk about orthodox principles of statutory construction, O and PACAR, what are the points of context that Sir James identifies as a pointer towards his meaning of Section 12.12? Aside from simply looking at Section 12.12 and saying that it's a broad power, there aren't any points of context that he draws our attention to. And we say the converse ultimately applies. And so that's the context in that sense, but it's also the context of these provisions in a wider statutory scheme. Because as my lords will have seen, the Public Order Act came in the following year in 2023. And we agree with the court's oral interventions that that date alone explains why that power doesn't really give us any assistance in construing what Henry VIII power introduced a year earlier was intended to do. And that point is consistent with a consideration of the detail of the 2023 Act.
What point are you addressing?
And now on the wider statutory scheme, my lord, I'm addressing Sir James's reliance on Section 34 of the Public Order Act 2023. And I'm saying that that provision doesn't give us any assistance in what the Henry VIII part was.
I thought the way you introduced it gives another aspect of context that you were relying on, but you're not. This is purely defensive.
It's in part defensive, and the next part is perhaps offensive, if I can put it that way, in every sense of the word.
Well, let's just stick with the.
But there's two ways.
Let's just stick with Section 34 first.
Yes. Section 30.
You say you agree with interventions by the court.
I think my lord.
Always remember what our intentions were.
I think the question that my Lord Vice President asked Sir James is, why does what Parliament did in 2023 give us any assistance in respect of what Parliament intended by this Henry VIII power in 2022? And we respectfully agree.
So it's simply a root and branch. What Parliament did in 2023 is in principle immaterial of what it must have intended in 2024.
2022. Yes, my Lord.
Precisely. Well, no, I observe that. I see the attraction of that performance sentence.
Yes, and
I'm not sure in the end, Sir James really. I have to look again at exactly what he said, but whether he really pressed that. The point he was making more was that here is Parliament
giving a meaning which
giving
is
a meaning
within
to
the range.
Serious
Yeah.
disruption, which specifically uses the yardstick of more than minor.
Yes.
And as a sort of general debating point, it's pretty remarkable if it clearly can mean that in primary legislation, as Parliament saying is, but it can't mean it in the context of the secondary legislation.
Yes. And my Lord, I have two answers to that point.
right, what namely?
So the first answer is that it's Parliament itself which is doing that. In section 34, Parliament is itself weighing the issues in the balance. It's not delegating those issues to the executive.
So Parliament itself can use more than minor in a, can use serious in what you would say, meaning other than it's not complete.
Yes, Parliament itself can
So
strike.
you wouldn't expect anybody else to do that.
Parliament can, yes, exactly. Parliament can itself weigh those issues in the balance. But the second answer, which is a more detailed answer, is that
Hang on 1 second, it's not convinced.
It sounds good when you're convicted of it. That's the point.
the second point, which is a detailed point, is that the statutory offences which the 2023 Act introduced were fundamentally different in their structure and purpose than the statutory offences in sections 12 and 14 of the Public Order Act. And so my lords will see, when going through those offences which are in tab 5 of the authorities bundle,
So just to be clear about this, section, we've taken to this rather briefly.
yes,
Object to that. But section 34.
applies for the purposes of this
Right,
Act.
only for the purposes of those 3 provisions.
Well, I think
looking on.
it applies for the purpose of the Act, but these are the primary offences which the Act introduced. It doesn't apply to any other Act. And in particular, it doesn't apply to the 1986 Act. But the statutory offences are different as well. So if my lord looks at locking on, for example, which is the offence at page 53 of the authorities bundle, that is an offence which has a reasonable excuse defence at section 1.2. And so my lord will recall that when we looked at section 12 and 14, there is no reasonable excuse defence in those offences.
Yes, thank you. Is that true of all of the offences?
Yes. It's the same in section 3.2, which is tunnelling. It's the same in section 4.2, which is being present in a tunnel.
And why is that relevant to this question?
Because if I can argue in defence to a criminal prosecution that I was exercising my free speech rights, then the court will judge those issues whenever it's convicting me or acquitting me. You can't do that in section 12 and 14. And that's what the authority of James demonstrates.
Authority of what?
James. Let me give my lord the reference. It's tab 30, page 656 of the authorities bundle, paragraphs 39 to 40.
Paragraph 39, 40.
Yes, of James. And so in section 12 and 14, the mere making of a condition means that it's proportionate for you to be convicted if you breach it. In these offences under the 2023 Act, I can argue that I was exercising my free speech rights as a defence to the prosecution. And so Parliament is weighing the free speech rights differently in a different context. And so those are the reasons of detail. And again, it's again obvious when we look at section 34.1. that section 34.1 only applies for the purpose of this Act. And again, it is phrased in a way which is different to the regulations. And so,
Hang on 1 second. So the concept of serious disruption is a key element in each of the three offences.
Yes. Serious disruption is a key element, but then I can then
Just
argue.
trying to identify the sense. It's basically, they're all structured the same way.
Yes.
It's sub B. Okay, thank you.
And these are also different kinds of protest, of course. My lord, these are tunnelling and locking on rather than processions and assemblies. And so what Parliament is doing is it's saying in these specific contexts, we're going to use a different interpretation of serious harm to the life of the community.
Why would the context of doing those different sorts of activity make a difference to the concept of serious disruption? You'd expect that to be the same across the whole legislative regime.
Well, you may have done, but Parliament itself may have thought that these things were inherently worse or more serious, and so the threshold for prosecuting and stopping them should be lower. And so
Sorry, say that again. Parliament might have regarded
these kind of
as
offences
less serious.
as more serious,
Then
as
why would the threshold be lower? Or am I confusing myself?
because well, Parliament may consider that there's a greater public interest in stopping them, and thereby give a lower threshold for stopping them than processions and assemblies, which Parliament may consider are of value and should be permitted to continue without interference in the rights context that we've started from. And so, far from helping Sir James, in my respectful submission, all these provisions show us is that Parliament gave a different definition of serious disruption in a different factual context. But then, if I could move...
So you don't disagree with Sir James's submission that what at least Section 34 shows is that more than minor is an available meaning of serious.
In
principle.
yes, it
You
can...
simply say that isn't meaning in Section
12 and 14, yes.
As originally construed, as originally enacted.
Yes, and just to put that point finally to bed, and this is the point which I described as offensive as it may be, if I could ask the court to turn up supplementary bundle tab 13, and this is the witness statement of Mark Williams.
Hang on 1 second. Yes, thank you.
Just before coming to that, Mr. de la Mare has asked me to remind the court that each of the offences in section 1 and 3 and 4 apply where 2 or more persons do something rather than to the conditions.
I'll ask you, this is Mr. de la Mare's point. Why does that matter?
They're simply different. They're completely different kinds of offences. But as my lord knows, when the Public Order Act 2023 was enacted, it followed on from a parliamentary procedure. And Mark Williams explains that procedure, paragraph 24 and 25.
Supplementary bundle,
Supplementary bundle
divided.
13, page 111. On the 7th of February 2023, the government amendment to the Public Order Bill, which would have amended the definition of serious disruption to the life of the community within sections 12 and 14, was defeated in the House of Lords by 14 votes.
So sorry, I was just looking at something else. Could you give me the paragraph number?
It's paragraph 24.
And that helps.
That helps because it shows, and if I could ask my lords now to turn to divider 30 within the supplementary bundle. The amendment which Mr. Williams has in mind is at the bottom of page 228.
Sorry, page again.
228. Yes,
What would it be for?
because Parliament rejected the application of the definition in section 34.1 to sections 12 and 14.
below.
Yes.
Whether that,
And
but we don't need to.
all that shows us
You're
is,
just making that good.
yes, making that good, yes.
Yeah.
And so, my lord, as the Divisional Court says, it's artificial not to have regard to that. The Parliament could have extended Section 34 definition to Section 12 and 14. It specifically refused to. And so, the proposition has to be that Parliament intended the Henry VIII clause to be used in a way that it itself had rejected.
No, but you can't have it both ways. If you're saying we can't look at what happened afterwards in the 2023 Act, nor do we really look at what happened with the progress of the 2023 bill, because what we're looking at is what Parliament intended in 2022.
Yes.
So why is it relevant that when Parliament was asked to make a amendment to primary legislation later, in terms which would then be made by the secondary legislation, that helps you construe what was intended in 2022.
Because if what was intended in 2022 was that the power could be used in this way, then this process which we're looking at in Parliament would have been
Parliament might
unnecessary.
change its mind.
Yes. Well, I agree. I don't put it any higher than that. I just say that it's confirmatory of the position that the Divisional Court came to. And so when we look at the 2023 Act, that's the extent to which it assists us.
Can I just ask, there's no challenge to any of the provisions in the 23 Act?
Not in this court, no. And so so what I've done is first of all looked at Section 12 and 14 language, then looked at them in their statutory context, also looking at them in their
Sorry, just want to read that. So the Divisional Court, I'd forgotten this, I'm sorry. The Divisional Court did pay some attention to that fact, since it was artificial to ignore.
that's the extent of it. Yes, it's paragraph 94, Roman numerals 3, at page 56 of the Divisional Courts of the core bundle.
Paragraph
94.3.
is this permissible for us to look at?
This is the Divisional Court's judgment.
Yeah, I realise that, but the Divisional Court, looking at it, and the Divisional Court itself said, we've got to be very careful about this.
Yes, no issues taken with this by the Speaker's Council's submission or by Sir James. And so the extent of the statutory context point, and this is why I said it was primarily a defensive argument, is that the 2023 Act doesn't really bring us any further forward. To the extent that it does.
2023 Act. No, Mr. I put you the logical, of course, you see the sort of common sense why that's a reasonable first reaction.
Yes.
But approaching the way you both, for different reasons, asked us to approach it, I think you agree that ultimately it's not really, it doesn't really help the argument.
It's
Have I misunderstood?
no, I agree. It doesn't.
I agree, right.
Yes,
So-
I agree. It doesn't take the argument any further forward, and that's why we look at the words. We look at the context, which is rights related and criminal. We look then to see whether there is any other admissible aid to the interpretation of the words.
Yes.
And so our case on admissible aids is that the words speak for themselves, particularly in their statutory and policy context. And it's only if the court's not with me on that it's necessary to have regard to any other extra statutory material. And one point which could be prayed in aid is the fact that the relevant government minister, when this power was introduced, said that it would only be used to clarify and not to change. And so the reference there is the Hansard material, that's supplementary bundle tab 28, page 219.
you're saying, as advocates generally do, is not necessary for parliamentary material
Yes.
because it's clear, adequately clear, like people think.
Yes, and Sir James.
But your fallback
Yes.
is that it's necessary. That is, if it is necessary, then looking at the ministerial statement, subject to what you say, is pure but it's perfectly natural use of parliamentary material.
Yes. And so again here, we can look at what it says, my lord. It's page 219. And so my lord will say halfway down the page, I now turn to the parts of the clauses that set out that the Home Secretary will have the power through secondary legislation to...
219?
Yes, 219 of the supplementary...
Halfway down.
Yes,
So that's in the speech
of the Victoria
Oh, I
Atkins,
see. Yeah, sorry, I hadn't realised. that
yes,
it's-
who was the Home Office Minister,
Right.
who introduced these provisions. And my lord will see, again, after she sets out what they're intended to do, she says, to clear up any misunderstandings, this is not about the Home Secretary of the day banning protests. Opposition members of
I haven't found the passage to clear up any misunderstanding. Where's that?
It's just after the quotation of serious disruption to the activities of an organisation which are carried out in the vicinity of
Oh, I see. Sorry,
possession.
yes, halfway through the line.
Yes.
Yeah, right.
So this is not about the Home Secretary of the day banning protests. Opposition members have understandably called for clearer definitions wherever possible, which is what this delegated power is intended to achieve. Any definition created through this power will need to fall within what can reasonably be understood as serious disruption. But then the important part, the threshold will be clarified, not changed. Such definitions will be used to clarify the threshold beyond which the police can impose conditions on protest. And so...
Well, it might be thought that the two sentences that you read out, any definition will need to fall within what is reasonably understood, the serious disruption. And the second sentence, the threshold will be changed, might be mutually inconsistent.
Well,
Which is one of the problems with
Yeah.
looking at this sort of stuff.
Again-
Or it might be thought, or it might be thought that the apparent inconsistency shows that what the phrase that you particularly like, the threshold will be clarified, not changed, is in fact to be read in the light of the previous sentence, in which case it helps Mr. James more than it helps you.
Well, given where we started, which is to look at the explanatory note, which explains that they are changing the threshold, and we're reading that in combination with what the Minister said they won't do, which is to change the threshold, then it is, in my respectful position,
You are not changing the threshold because it will be serious disruption. It will still have to be within an available meaning of serious disruption.
yes.
Serious disruption is a phrase which is capable of having more than one meaning, or broad meaning or narrow meaning. And where it clarifies that it has the broad meaning.
Well,
That doesn't involve any change. It's merely clarifying which two possible meanings is the one that applies.
again, with respect, the way we interpret this, and it will be for the court to determine, is that the first sentence says, what can reasonably be understood as serious disruption. That is a reference back to what Parliament had always intended serious disruption to mean in section 14.
This shows the fact that we have to enter into a constructive exercise about what the Minister was saying, shows why this is so rarely a useful exercise.
Well, again,
It's
in
a
my...
secondary part of your case, I do agree.
Yes.
It all becomes circular
And it,
on whether your first argument or his first argument is right.
yes,
And then there are bits which you can cherry pick and support your argument.
well, in my respectful submission, the changing of the threshold is not cherry picking. That's exactly what the Minister said she wouldn't do. But in any event, my Lord knows my submission on this, and my Lord knows that the Divisional Court again used this as confirmatory of its conclusion that it had already come to in any event. And so, insofar as there is ambiguity, because Sir James's case is the polar opposite of mine, which is that section 12, 12 and 13 aren't ambiguous because they have the opposite meaning to the one for which I'm contending. Insofar as the court considers that there are two tenable interpretations of this statutory provision, then there may be ambiguity that may justify having regard to the minister's statements, and the minister's statement assists us on this. And again, that's exactly what the House of Lords did in the Foster case, on which my learned friend Sir James places so much reliance. In that case, the House of Lords considered that the phrase, the clause in that case was undoubtedly ambiguous. That was a deeming provision, not a Henry VIII provision. And the reference there is Authorities Bundle tab 11, page 167. And so if Sir James is right, that fosters the same wording as this case, then the House of Lords' conclusion in that case that there was undoubted ambiguity allows this court to look at what the minister says. And my lord, those are the submissions so far in respect of statutory interpretation and in respect of what the regulations did. Those are the first two stages of my argument. The final stage is the Henry VIII stage, but I'm conscious of the time.
I think you can. Yeah, we'll run a bit longer.
I'm very grateful.
Sorry.
If we get a clean break and then just hear the sequence tomorrow.
Yes.
You taken us to paragraph 167, page 167. Which letters do you want us to look at? Is it B to E in Foster? Because it's not paragraph number.
Yes, it's C. It's C. Section 20. Section 22(4) is undoubtedly ambiguous. That's a difference in opinion if the courts below clearly shows. And for my lord's note, the statutory provision in that case was one about treating something as being within the concept of a particular social security provision. It's page 162D. It's that regulations may specify circumstances in which persons are to be treated as being or not as being severely disabled. And the reason why the House of Lords concluded in that case that that was permissible is because of the statutory context that arose in social security legislation. And my lord will see the reasoning of the importance of legislative context at page 163G onwards. And so all a Foster is a deeming provision, which is different to a Henry VIII provision. It didn't change primary legislation, and it had a particular meaning because of its context and its legislative context. And that's the extent to which it assists us. Insofar as Sir James is right that the provision was undoubtedly ambiguous, then it gives us a gateway in to looking at the minister's statement. And the minister's statement is that it will clarify, not change in this case. And so from turning then to the final stage of the argument, my lords, I'm conscious of the time. So far our analysis has been based on straightforward principles of statutory construction. What do the words say? What's their context? To what extent is there ambiguity? And we say the answer is clear, but the answer is all the more clear when we look at the key Supreme Court authority on Henry VIII clauses. And what that case is the Public Law Project case, which is at tab 31 of the Bundle of Authorities. It may be the second volume of the Bundle of Authorities. The court may remember what this case was about. It was about the introduction of a residence test for legal aid in LASPO. And the statutory provision is in the judgment of the Court of Appeal at page 664, paragraph 5. And the statutory provision in particular at section 9.2 allowed the Lord Chancellor by order to vary or omit services described in that part. And what the Lord Chancellor did was, by order, he varied or omitted services provided to people who weren't resident in this jurisdiction. And so, in one sense, this is exactly like what Sir James is saying in this court, which is that is the wording broad enough to incorporate what I said? And that reflects the exact language of his argument in Public Law Project. And my Lord will see that at page 679, next to E. Sir James's argument in Public Law Project started with the starting point for the exercise of statutory interpretation should be the statutory language itself. The language of the relevant provision is plainly wide enough to encompass the proposed residence test. And then over the page at B to C on 680. The scope of section 9.2 is a question of interpretation, the answer to which is clear. Any presumption towards a restrictive interpretation only arises where there is...
Sorry, where are you reading?
Between B and C on page 680, my Lord, it starts...
Still within Sir James's argument?
Yes.
Yeah.
And my Lord will say, it says that just next to B, the fact that the primary legislation insists on affirmative resolution procedure is significant. The scope of section 9.2 is a question of interpretation, the answer to which is clear. Any presumption towards a restrictive interpretation only arises where there is genuine doubt about the scope of the power. Here it is clear from the terms of the statute that the power is intended to be very broad, giving a wide-ranging power to amend the scope of legal aid coverage. That's his exact submission, which he makes in this appeal. And the Supreme Court rejected that submission. And it did so in terms at paragraphs 20 and onwards, starting at the bottom of 684. And all of these paragraphs are of importance, and I'll invite the court to read from paragraph 24 to 28. Can I emphasize the following points? The court accepted that at paragraph 21, that subordinate legislation consists of legislation made by members of the executive, often government ministers, almost always pursuant to an authority given by Parliament in primary legislation. And it noted in that case that it was the affirmative procedure, just as it was in our appeal. And then at paragraph 22, although they can be said to have been approved by Parliament, draft statutory instruments, even those subject to the affirmative resolution procedure, are not subject to the same legislative scrutiny as bills. And unlike bills, they cannot be amended by Parliament. And then at paragraph 25, we have the citation from Crays on legislation, which explains what a Henry VIII power is. And it says, when a court is considering the validity of a statutory instrument made under a Henry VIII power, its role as upholding parliamentary supremacy is particularly striking, as the statutory instrument will be purporting to vary primary legislation. Then at paragraph 26, in the case of an amendment that is permitted under the Henry VIII power, as with all delegated powers, the only rule for construction is to test each proposed exercise by reference to whether or not it is within the class of action that Parliament must have contemplated when delegating. And so pausing there, that's the question which I asked at the start of my submissions.
Sorry, I picked you up on it.
Not at all, my Lord, I should have realised that's where I got it from. Although it sounds much better when Lord Neuberger says it. Although Henry VIII powers are often cast in very wide terms, the more general the words used by Parliament to delegate a power, the more likely it is that an exercise within the literal meaning of the words will nevertheless be outside the legislature's contemplation. And again, that's Sir James's point. This is within, and we say only just within, a possible literal interpretation of the words making provision about the meaning. But the fact that that is only just within makes it all the less likely that it was within the legislature's contemplation. And then we have at paragraph 27 the emphasis on all of those cases, Spathholm and McKiernan. And again, Lord Neuberger approving McKiernan, saying, whether subject to the negative or affirmative resolution procedure, subordinate legislation is subjected to much briefer, if any, examination by Parliament and cannot be amended. The duty of the courts being to give effect to the will of Parliament, it is, in my judgment, legitimate to take account of the fact that a delegation to the executive power to amend primary legislation must be an exceptional course. And if there is any doubt, not just any genuine doubt, but any doubt about the scope of that power conferred upon the executive, it should be resolved by a restrictive approach. And then again, that being approved at paragraph 28. And Lord Neuberger applied those principles at paragraph 30, my lord. In my view, the argument is sound and should be accepted. Turning to section 9.2b itself, as a matter of ordinary language, the relevant parts of the draft order do not seek to vary or omit services, rather they seek to reduce the class of individuals. Of course, the words of section 9.2b have to be interpreted in their context, and I accept that a sufficiently clear and strong context could justify a different conclusion, in the sense that the words of section 9.2b could, as a matter of language, just about extend to a regulation such as the draft order. Nonetheless, that is not their natural meaning. And of course, the natural meaning of the words in question is an important factor in statutory interpretation, particularly when Henry VIII power authorises the delegation of subordinate legislation. And so, public law project, which Sir James conspicuously didn't address in his oral submissions, is an answer to his fundamental case on ground one, because just about section 12, 12 and 13 could allow a redefinition, but that's not their natural and ordinary meaning, and because it is a Henry VIII power, that's all the more reason not to give the wide reading that Sir James urges. Another case which Sir James didn't address is the Arbab case, which is the very last case in the bundle of authorities. And Arbab is a judgment of this court.
You wish to write it?
46.
Thank you.
And so to explain the context here, my lords.
Will this be the last part of your submission?
Yes.
Okay,
This appeal concerns legislation which provides for a review of HMRC decisions about tax credits in advance of an appeal to the first tier tribunal. And so what happened in that case is that secondary legislation, you can see this from paragraph 14, introduced a procedure which had the effect of removing an appeal mechanism if you hadn't applied for a review. And again, the governing power in that case was widely worded, and my lords will see this at paragraph 20, in fact, at page 1188. And the relevant provision said that the Treasury may, by order made by statutory instrument, make provision for and in connection with reviews by the commissioners. And again, it was within the wide wording of that provision that a review mechanism could be introduced. And what Lady Justice Falk started with is by looking at Henry VIII authorities at paragraph 39 and saying if there's any doubt or any genuine doubt, then you apply a restrictive approach. And in that case, the restrictive approach was all the more justified because a constitutional right was an issue. In that case, the review mechanism helped to inhibit access to a court.
Where do you see that being dealt with?
Paragraph 46 and paragraphs 59 to 60.
Right. Well, that's
And so again, what we have here is in Public Law Project and in Arbab, the statutory provisions were wide enough to conceivably include the approach being urged by the executive. In both cases, nevertheless, a restrictive approach was applied. In both cases, the statutory provisions were subject to the affirmative resolution procedure. Nevertheless, a restrictive approach was applied. In the RBAB case, as in our appeal, constitutional or fundamental common law rights were an issue. As a result, a restrictive approach was necessary. And so it follows that, in my respectful submission, Sir James is wrong to treat the existence of a wide power as something which in and of itself is decisive about the question in this case. And so for that reason, and all of those set out in writing, we respectfully invite the court to reject part one of the appeal. Subject to anything else I may say just in the morning, it's over to Ms. Higgins.
You'll have the opportunity to.
I'm very grateful, my lord. I'm sorry for taking up so much
Each
time.
into these,
I'll try not to.
time in the morning. Has someone agreed how to squeeze in something like that? Squeeze in is not like give it ample.
I think we'll do our best, my lord, is the proposal. Mr. De La Mare has asked for 15 minutes, and it will depend on how quickly Ms. Higgins gets through the consultation points in the morning.
They'll manage it.
Yeah.